Sponsors and pre-incorporation contract. Definition of sponsors. Promoter is a person who decides a plan for a business venture, one who takes the preliminary steps necessary for the formation of a corporation. According to Cockburn CJ in Twycross vs. Grant, the effect that a promoter is one who undertakes to form a company with reference to given project and to set it going, and who takes the necessary steps to accomplish the purpose. A promoter may be a nature person and may continue to be a promoter even after the company had been incorporated. Duties of a sponsors. To disclose the secret profit. The sponsor should not make any secret profit. It is his duty to disclose all the money secretly obtained by way of profit. To disclose all the material facts. The sponsor should disclose all the material facts. A company may affirm the contract and obtain all the profit when the sponsor did not disclose the contract of selling a property to the company. The sponsor must make good to the company what he has obtained as a trustee. A promoter stands in a fiduciary position towards the company. It is the duty of the promoter to make good to the company what he has obtained as a trustee. Duty to disclose private arrangements. It is the duty of the sponsor to disclose all the private arrangement resulting in profit by the promotion of the company. Duty of sponsor against the future allottees. When it is said that the sponsors stand in a fiduciary position towards the company, then it does not mean that they stand in such relation only to the company or to the signatories of memorandums of company, and they will also stand in this relation to the future allottees of shares. Pre-incorporation contract. Effects of contract under common law. A pre-incorporation contract is entered into by the corporate sponsors who form the company by filling its article of incorporation. Since the corporation has not been formed yet, it cannot be a party to the contract. If the corporation is not formed or if it fails to adopt the contract, the sponsors can be held personally liable for any breach of the contract. This is because a company has no entity before a company is incorporated. A promoter is paid a registration fee using his own money. He cannot make any claim from the company since the company does not exist yet. There is no contract since there is no company which can be the principal for the agent to the contract on behalf of. Effects of the contract under the Companies Act 2016. Section 65 subsection 1 of the Act allows a company to ratify or accept any contract or transaction entered into or made before its incorporation after the company is incorporated. Once the contract is ratified, the company is fully liable on the contract from the date the contract was signed. Section 65 subsection 2. There are two conditions to be fulfilled in order to make a pre-incorporation contract valid and binding upon a company. The contract should at least have been entered into by the company or by any person acting on behalf of the company before its incorporation, and the company must ratify the whole pre-incorporation contract after its incorporation. occupation occurs when the company occupies the rented office space.
Lifting of the corporate wire statutory exception. This section provides that a company may distribute cash dividend to its members only out of its profit. Company director who willfully pays dividend of the exceeding company's profit will be liable personally to the company to the extent of amount exceeding of the profit or the amount due to its creditors. Fraudulent trading. Section 540 Subsection 1. Section 540 Subsection 1 Liability on the officer responsible for fraudulent trading by the company. Fraudulent trading occurs when an officer of the company carries on any company's business with an intention to defraud the company's creditors. Section 540 Subsection 2. Read together with Section 539 Subsection 3. Winding up of a company and the company's office continues to contract a debt for the company and he or she has no responsible or probably expecting that the company will be able to pay the debt. The officers will be held personally liable with any limitation either wholly or partially for the repayment of the debt. Default in Contribution. Section 46 Employees Provident Act 1991. The Employees Provident Fund (EPF) is a social security institution formed according to the law of Malaysia, which provides retirement benefit for the members. Employer and employee are required by law minimum of 12% and 11% respectively of the employee's salary to the fund. The directors of the company, at the same time the action is taken at the non-contribution, are jointly and severally liable with the company. Default in Contribution. Section 108A Employees Social Security Act 1969. SOCSO was established to provide coverage and protection for the benefit of employees who may be involved in an accident at work or who may be contract some occupational disease. The defaulting employer is a company. Under the Act, the directors of the company at the same time of the taken and non-payment are jointly and severally liable with the company for the amount unpaid. Definition of common law. Common law is the main body of law which has been developed over many years as the result of various judicial decisions of court judges. In a common law, a legal case could establish a value or a ruling that courts of different judicial bodies are destined to decide a subsequent case with very similar issue and facts. The courts are bound to follow rules of reason which have been used in prior decision when resolving disputes of the same nature. The decision of the court make a binding only in a particular jurisdiction, and certain courts have more power than others. Supporting case. Prevention of Fraud. River Motor Corporation vs. Horn, 1933. (935) is a UK company law case concerning piercing to the corporate wire. It gives an example of when courts will treat shareholders and a company as one, in a situation where a company is used as an instrument of fraud, where the company is acting as an agent of the shareholders. F.G. Films, 1953. A British company with no premises except a registered office and no employees, and which had finances, films rights, and facilities provided for by an American company, was denied its request to register its film as a British film under the Cinematography Film Act 1938-48. Supporting case. Determine of the character. Demarco vs. Continental Tire and Rubber, 1916. A UK company law case concerning the concept of control and enemy character of a company, it is usually discussed in the context of lifting the corporate veil. However, it is merely an example of where the corporate veil is not an issue as a matter, since the decision turns out correct in the prayer of a statute.